Well, good evening, everyone, and welcome back to AJ 101 Criminal Law Online. My name is Tony Farrar, and I am your instructor for this semester. Tonight, we are going to jump right into Chapter 2, which is Classification of Crimes and Penalties. Now, this chapter, especially at the beginning, gets a little bit confusing. So this is going to be one of those chapters where I would highly recommend that you take the time to read it again in your textbook so you really grasp a lot of the content, and that you can add some context to some of the discussion points that we're going to go over. There's a couple of case laws in there that are of particular importance that I would like you to kind of look at. But all in all, again, this is going to be one of those chapters where it's going to be incumbent upon you to fill in the holes and fill in the blanks and help add that context to the lecture by reading some of the discussion points and things that are in your textbook. So with that being said, also do not forget at the end of this chapter, you will find the terminology and definition area. You will find also a short practice true or false question quiz. There will be some short essay questions for you to read and perhaps even answer, which will help add some further context to the conversation. And then also they have that really cool terminology matching quiz at the end of the chapter as well. So let's go ahead and jump right into Chapter 2, which again is Classification of Crimes and Penalties. So criminal statutes may not, by interpretation, be extended beyond their plain meaning, unless, of course, common sense or the obvious purpose of the legislature so requires. In the interpretation of statutes or the construction of the words in these statutes that we're talking about, the defendant is entitled to the benefit of every reasonable doubt, just as he or she is as to questions of fact involved. And there's a case that goes with that. It's People versus Davis, and you can look at it on page 19 in your textbook. Often a word, whether coming from a foreign language or coined to meet a particular need, has been used as an English word to such an extent that its meaning has become commonly understood. In such instances, it becomes part of the English language with the meaning attached to it by such use. Such is true even if the word is not in the English dictionary. And that basically says that there are some words out there that we know that might be slang words or buzzwords or whatever you want to call them, but we use them so often that everybody kind of knows what it means. So just because it's not located in the dictionary doesn't mean that it's still something that we can't use or something that isn't commonly understood. So how to read a criminal statute? Well, it's telling us to use the plain meaning of the written law. Okay, and unless common sense or obvious purpose of the legislature dictates something else, we are to use that plain meaning. We're not to add words or do anything else. We also have to remember that the defendant here is entitled to every reasonable doubt. And finally, we just put a little emphasis on this, that words from foreign sources take on their commonly understood meaning in our culture, and that is okay. So we don't have any problems with those. Now, there are some times where we're going to run across some things that are so vague or indefinite, as it's called, meaning not precise or exact, that there's going to be some issue with that, which is going to cause something to happen. And here's kind of what I mean, and I don't want to get ahead of myself. So here's some terms or things that we kind of need to know. So vague means uncertain or unclear character or meaning. So criminal statutes which are vague and uncertain will result in a violation of the Due Process Clause of the 14th Amendment to the United States Constitution. And that's important for us to know, because if those sections are vague, then we're not going to be able to uphold those laws. So they're indefinite, meaning they're not precise or exact. And these types of laws will in fact result in a violation of due process, which I just stated, the due process clause of the 14th Amendment. Now, a couple of those words that are out there for us to kind of consider would be words like immoral or loiter. If used in a crime, they would have to be very, very clearly defined to not be vague. Okay, does that make sense? Because let's look at it this way. If I ask you what the word immoral is in a crime, so let's say that drawing pictures of somebody's rear end is immoral or whatever, but regardless of how funny my analogy is, we all have a different interpretation of immoral. It's not defined. What I think is immoral might be different from what you think is immoral. It goes along with the same thing with loiter. So what the law is telling us here, words such as immoral, or loiter really have to be clearly defined to make them constitutional. So if we're going to put these in a law, in a crime, and we're going to prosecute, we need to define what immoral is, what the immoral thing is, or we need to define what loiter is, or what actions constitute loitering. So I hope that kind of makes it a little bit easier. So words such as immoral or loiter, if used in a crime, again, would have to be clearly defined in terms of specific acts or actions in order to be constitutional. Otherwise, such laws will be declared void as being vague or indefinite. And no one can be punished for mere intent to violate the law or mere intent to do an act prohibited by law. It does take, remember, especially we talked about it in California, it takes some kind of actual overt act or omission, okay, which is specifically prohibited or required. So hopefully that kind of clears up, yeah, that's kind of funny, clears up the vagueness there, and we have a better understanding about how that works. Now, when we talk about the construction of penal statutes, we're talking about not necessarily how they're made, but kind of how they might be classified. Okay, and the California legal system is in part based on the English common law system. However, remember, California jurisprudence or law is less tied to tradition, right? Because we don't have common law, and is more people-oriented than is old common law. Common law is bound by what they call the letter of the law, meaning black and white, the letter of the law. The California legal system is directed more toward the spirit of the law. The California legislature expressed that intent specifically in 1872 by enacting Penal Code Section 4, which reads as follows. So you can listen and follow along here if you're looking in your book. The rule of common law that penal statutes are to be strictly construed has no application to this code. Okay, so you get that, right? No common law. All its provisions are to be construed according to a fair import of their terms with a view to effect its objects and to promote justice. Okay, so that's end quote. So that's kind of what it talks about in Penal Code 4. Thus, when a reasonable question arises as to the meaning or intent of a given law, the courts are going to look not only at the literal meaning of the words used, but also the spirit in which the law was written and the legislative intent behind it. And once the intention of the legislature is determined, it will be given effect even though it may not be consistent with the strict letter of the statute. And there's a case that goes with that. It's In Re Colli D. Similarly, when construing a statute and seeking to determine the legislature's intent, interpretation must be given which avoids any absurdity, meaning kind of craziness, if you will, especially one which goes outside of the offense sought to be prohibited. So what we're talking about is when language can be interpreted two different ways, we well use that which is more favorable towards the defendant. Okay, and then we kind of already talked about this. Courts not only look at that literal meaning of words, but also the spirit in which the law was written and the rationale for its intent. Now, I could probably kind of give you, because this is going to be a little bit of a shorter chapter, an example could be a law against, if you remember, New York tried to enact a law where you couldn't have a soda that was of a certain size. Let's just say it was a big gulp size, like a 64 ounce, if that's what a big gulp size is. And you know, the intent of that law may have been to make people healthier, okay? And maybe this isn't the best kind of, you know, example to look at, but, you know, if this were to be brought up and somebody were to be, you know, say cited for something like that or taken to court, the court is really going to look at the literal meaning, not just look at the literal meaning of the words, but they're going to look at the spirit in which the law was written and its overall legislative intent. So what do we do when there is a kind of a conflict between statutes? Well, where two state laws punish exactly the same act or omission as crimes, okay, and they are obviously in conflict, the last one passed into law will control that, and that's People versus Jones, and you can see the case law there. And again, you don't have to read every single one of these case laws, but it's nice to reference them in case you decide that you find something that might look interesting and you actually kind of want to take a look at it. So the term conflict between statutes, though, just remember, should not be confused with that concept of preemption that we looked about earlier. The concept of preemption means that state laws take priority over city and county ordinances. Here we're talking about conflict between statutes refers to conflicting state laws. So I hope that kind of clears that up for you as well. So some important terms to know, and there's a lot of them that are listed on page 20 in your textbook, and we're not going to go through them, every single one of them, but these are a couple of them that I think are really important. So words used in the penal code in the present tense include the future as well as the present. Words used in the masculine gender include the feminine and neutral. The singular number includes the plural, and the plural includes the singular. So when you read codes and things, don't get all huffy or whatever because it might say his instead of her, or hers instead of his, or you know, a couple other examples. So the word person, to give you an example here, includes a corporation as well as a natural person. The word county includes city and county. Writing includes printing and typewriting. Oath includes affirmation or declaration. And every mode of oral statement under oath or affirmation is embraced by the term testify. And every written statement is included in the term depose. So it's, when you look at these, you have to look at the words and you have to really kind of know what they mean, because that will help you add context again to what we're kind of talking about. So some of the important ones to look at would be willful, a purpose or willingness to commit the act. No intent to violate the law, just a purpose or willingness to commit the act. Negligent, a want or a lack of attention to the probable consequences of the act which a normal person would respond. Malice, everybody's probably heard that word. To vex, annoy, or injure another person, or the intent to do a wrongful act. Knowingly, only the knowledge that the facts exist. Doesn't require any knowledge of unlawfulness. So this is a state of mind, doesn't require intent. So again, you may have thought some of these words were a little bit different as you saw them up there. And now you're looking at the true meaning. If you look at page 20 and 21 in your textbook, it goes through a lot of the different words and helps you kind of figure out what their really true meaning is. And I'll give you one other example. Let's see. The word bribe signifies anything of value or advantage, present or prospective, or any promise or undertaking to give, asked, given, or accepted with a corrupt intent. So here's one with an intent. So again, take the time, if you would, to look at some of those so you kind of understand the actual true meaning of each one of those words. So we're still in, chapter 2, and we're talking about classifications of crimes and penalties and things like that. So let's look at crimes in California. So how do we classify them? Well, these are things you've probably heard from watching maybe your favorite police show or what have you, or taking some other classes. Crimes in California are divided into 3 different categories. They're found under Penal Code 16. And if you ever want to look up a penal code, you can just go to Google. You can type in California Penal Code 16, and you'll be able to get like a definition. It'll take you to one of thousands of different websites that have this information. So the first is going to be a felony. And this is a serious crime. It's found under Penal Code 17. So again, you can look it up and you can get the actual definition if you want. But it's a serious crime punishable by death, state prison, or county jail for a felony term. And typically, it's going to be imprisonment in the state prison or in the county jail for a term of 16 months, 2 or 3 years, or for a longer period as specified by statute, because some statutes will tell you how much time you're going to do. That's the punishment part, remember, in order for it to be, a crime or a law. The next one here is misdemeanor. It's a moderately serious crime punished by county jail time or a fine or both. And again, so that's kind of like the second level with you. So every other crime or public offense is a misdemeanor except those that are infractions, and we'll kind of talk about the last one. That's an infraction. That's the least serious crime, and that's probably one that you might have had some more exposure to. So a traffic ticket, that would be an infraction. So an infraction is not punishable by imprisonment. A person is charged with an infraction shall not be entitled to a trial by jury or to have a public defender or other counsel appointed at the public's expense to represent him or her unless he or she is arrested and not released on the promise to appear or on their own recognizance, meaning like you're released but you're promising to come back, or a deposit of bail. So technically, let me ask you the question, if you get a traffic ticket, is it an arrest? Kind of just mull that around in your mind for a while, and I'll give you the answer a little bit later as we start to go into arrests and things like that. But the infraction you can find under Penal Code 19.6 if you want to look at it a little bit more. Now sometimes, even though we have felonies, misdemeanors, and infractions, we also have other important Penal Code sections that are there, and you can go through these at your leisure as well. But all the codes are listed here, such as Penal Code 16 talks about kinds of crimes. Penal Code 17, the ones we were in, was classifications of crimes. And then you can kind of look all the way down and see some of the other different ones that are out there. Now, on this particular slide, one of very significant importance would be Penal Code Section 296. And this talks about DNA database specimens, and I felt it important to take a little bit of time and kind of talk about this one. First of all, let me back up to the one in front. So you're looking at PC 19.8, penalty for infractions. Remember, we talked about that, except where a lesser maximum fine is expressly provided for violation of the above section. Any such violation is in fact an infraction and is punishable by a fine not exceeding $250, unless of course it's expressed or written in statute that it's going to be more. But we know the infraction, that's the lowest one. So now the DNA database. So section 296, persons convicted of enumerated crimes or certain crimes, and you can look up the different crimes. I'm not going to go through them all for you. You can find those. Are required to provide 2 specimens of blood, a saliva sample, right thumbprints, and full palm prints of both hands for inclusion in state databases. The specified crimes, I'll give you a few, include registerable sex offenders, murder, voluntary manslaughter, felony spousal abuse, aggravated sexual assault of a child, felony assaults and batteries, kidnap, mayhem, torture, first-degree burglary, robbery, arson, carjacking, and terrorist activity. Officers are authorized to use reasonable force to collect specimens from those who refuse to provide them. Now, here's an important section, and we'll talk more about this later. Penal Code 298.1 subsection B subsection 1 talks about the authority of officers to use reasonable force to collect a specimen from those who refuse to provide them. Now, of significant importance, okay, the U.S. Supreme Court has ruled that as part of a routine booking process for serious offenders, officers may take what they call a buccal swab or a cheek swab for DNA database. Now, this case, Maryland versus King, is a case that I highly recommend that you take a look at. Okay, so all the information is there for you to look it up, pop it into Google, take a look at the case. It's very, very important, and it has a very significant evidential impact and criminal procedure and criminal law impact as well. So take the time to kind of go through that case. It's very, very important. So moving on now, while we know the classifications of crimes are felonies, misdemeanors, and infractions, there are in fact some that they call wobblers. Now, some of these crimes provide for an alternative sentence. They are punishable either as a felony or a misdemeanor, and they're called wobblers. So some crimes can be punished as a felony or a misdemeanor. This is known as a wobbler. And sometimes a wobbler filed as a felony will be reduced to a misdemeanor by the judge at the preliminary hearing. Sometimes the prosecutor will file a wobbler as a misdemeanor from the very, very beginning. Unless filed as a misdemeanor or reduced at the preliminary hearing by the judge, wobblers tend to be, for all intents and purposes, are felonies. Okay? Especially at the time of rest, up to the time of actual sentencing or granting of probation, etc. Now, a wobbler becomes a misdemeanor when filed as such by the prosecutor or is reduced to a misdemeanor by the preliminary hearing judge. For example, so here's an example of one. Okay, a person may commit an offense such as burglary in the second degree. So Penal Code 459 is burglary, which is a felony, but which may be designated as a misdemeanor in the discretion of the prosecutor at the time of charging or by the court after preliminary hearing or at sentencing. Okay? If not filed as or reduced to a misdemeanor, the offense is a felony up to the time of sentencing. So again, there's kind of a lot to this wobbler thing in here, because some felony wobblers are punishable by state prison and others by incarceration in county jail. There are both prison wobblers and jail wobblers. And a wobbler declared to be a felony will be punishable in the state prison if the statute does not specifically or specify a county jail sentence. So just remember that wobblers, the easy way, I know this was a lot of legal ease, but if you just kind of think of, a wobbler, there are some felonies that can basically be filed as misdemeanors, and it can be done by the prosecution at the time of filing. It can be done by the judge at the preliminary hearing, or it can be done at sentencing as well. So there are some other things to consider, and I'm going to let you kind of look at these at your leisure. So we're talking here punishment for offenses not otherwise prescribed. So there are a lot of things in here that talk about, classifications of crimes and different things. Well, here we have felonies when not otherwise prescribed, maximum term for a misdemeanor offense. So, how long will somebody for a maximum term for a misdemeanor? So an example for that one is Penal Code 19. So you could actually look it up. It's Penal Code 19.2. And it says, except where a different punishment is prescribed for a misdemeanor, meaning that something else is already written down there, it will be punishable by imprisonment in the county jail, not exceeding 6 months, or a fine of $1,000, or both. Does that make sense? And typically misdemeanor offense jail terms don't exceed the 1-year mark, which is why they have 364 days down there. So again, take some time to kind of walk through some of these different things, and it will definitely help you add some context to the conversation. And then as part of the classifications of crimes and penalties, sometimes there are initiatives and measures that come forth where petitions are signed by a certain number of registered voters, and they can force a public vote on a proposed statute or constitutional amendment. Now, in California, 2 such propositions to amend criminal laws and procedures were Proposition 8 and Proposition 115, and I'll talk about Prop 47 kind of towards the end. And I'm not going to go through the entire list of all the different things that changed here, but these were some major Proposition 8 and Prop 115 changes. So again, California voters occasionally pass ballot measures to amend criminal laws and procedures, as in 1982, Proposition 8, and in 1990, Proposition 115. And such measures often reflect a popular sentiment that legislative and judicial actions or inactions are out of touch with the public's will, meaning like, hey, we need a change on this. Both of these measures were aimed at restricting the rights of the accused and extending the abilities of the state to prosecute, thus bringing California more in line with the federal rules and the majority of other states. And again, in your textbook, you can look in section 2.9 on page 24. It talks about a little bit more in detail about each one of these. And then again, we'll kind of look at Prop 47 and what have you. But if you look as we start to go down here, so there's rules of evidence, bail provisions, use of prior convictions, prior conviction as an element of the offense, diminished capacity, insanity. So those are they're all important, but part of what Prop 8 and 115 did, the changes that were under Proposition 8, basically diminished capacity was abolished. So the defense of diminished capacity was abolished, and basically the insanity defense, there were some elements that were added. So let's take that one as an example. In any criminal proceeding, including any juvenile court proceeding, in which a plea of not guilty by reason of insanity is entered, this defense shall be found by the trier of fact only when the accused person proves by a preponderance of evidence, greater weight, that he or she was incapable of 1, knowing or understanding the nature and quality of his or her act, and 2, distinguishing right from wrong at the time of the commission of the offense. It wasn't like that before. So these are some changes. So remember, Prop 8, Prop 115 was kind of meant to restrict the rights of the accused a little bit, but extended the abilities of the state to prosecute, and kind of help the state out a little bit as far as prosecution goes. But again, I'm not going to go through all of these different sections, but these are some of the major changes that were actually noted. And then Also, Prop 147, which I'll get to, I guess, in just a second. So here's a couple of prior conviction penalty enhancements that were also looked at. So petty theft with a prior, there were some changes because of that in Prop 147. Those who are armed and use a firearm, prior serious convictions, prior felony convictions. So these are things that, you know, that really helped out the courts as far as what you can do. And all these are listed in your textbook. So I want to make sure that you had a good understanding of that, but I'm going to let you take the time to read it. Now, before we move on to these prior convictions for you know, juvenile justice or things like that, I want to go back really quick to a ballot measure known as Prop 47. So Prop 47 was approved by voters and became effective in November 2014. The effect of this prosecution was to reduce the seriousness of a number of crimes, both as to future prosecutions and as to those already convicted. Now you got to think about that. Okay, let me read that again because I want to make sure you caught that. The effect of this proposition was to reduce the seriousness of a number of crimes, meaning that we're going to take them from maybe a felony to a misdemeanor, so seriousness, both as to future prosecutions, so the ones that are coming up that maybe somebody will get arrested later on, and those already convicted. So if you think about that wording right there, that could actually mean, and it does mean, that those that were already convicted at a certain level, could they in fact petition the court to have their sentence reduced? Because the crime of whatever is now different. The penalty is different. So yeah, you have to look at the big picture on things like that. So here's a couple of things that fall under 47. They added a new crime of shoplifting. Penal Code 459.5, and the reason they did that was probably because of the amount of shoplifting that takes place out there. The amount of the value of loss separating misdemeanor wobbler classifications in such crimes as theft, forgery, receiving stolen property, and writing checks with insufficient funds was raised from 450 to over 950. So before, you could get arrested for things like petty theft or whatever if the value was, you know, that under 450. Well, now they've raised it up to 950, where if the old law was there, if you got arrested and the value of something was 950, it could be a felony. But now it's only going to be a misdemeanor because they raised the dollar amount, if you will. And I'm not saying it's a bad thing. I'm just giving you the context of how all this works. Personal possession of certain drugs, such as heroin, cocaine, concentrated cannabis, methamphetamine, was reduced from felony to misdemeanor. How do you feel about that? Some of you, again, and we'll talk about this in class, that some of you, you know, on the discussion board, some of you might think, hey, that's okay. Just because you get arrested once for possessing some of this stuff, maybe you should get a break. And some of you are probably hard line and saying, well, no, hey, dude, you got arrested for this, so you do the crime, you do the time. And but it gives that opportunity for those to get a misdemeanor instead of a felony. Procedures were adopted permitting those defendants previously convicted of felony offenses that would now be misdemeanors to petition the court for resentencing and modifying their criminal history records. So we're going to take all the time and manpower and go all the way back and change. They can petition the court to have their sentence changed. Now, some may think that's fair and some may think that's not. But these are some of the things that took place under Prop 47. Again, I'm not going to tell you which side of the fence I'm on. I'm just telling you what's on both sides of the fence. So you can kind of make your own determination on that. So now we're going to move on and talk a little bit more about prior convictions here. So any person 18 years of or older at the time of the commission of any crimes listed in Penal Code 1192.7, so there's a certain list of crimes there, and they're usually the more serious ones, is not eligible for commitment to the California Department of Juvenile Justice. So what they're saying is if you're 18 years or older at the time that you committed a murder, you're not eligible to be put in juvenile hall. Does that make sense? And there are some other crimes that are listed in there, but these are some of the other reforms and things that have kind of been coming out of what we're doing. So moving on now to lesser and included offenses, and you've probably heard the phrase before on what lesser and included offense is. So in California, there are several offenses, the commission of which necessarily includes other lesser offenses. And I know it sounds confusing, but I'll kind of clear it up. However, before a lesser offense may be said to constitute let me start that again. In California, there are several offenses, the commission of which necessarily includes other lesser offenses. However, before a lesser offense may be said to constitute a necessary part of the greater offense, all of the legal elements of the lesser offense must be included in the elements of the greater offense. Okay, legalese, I get it. Okay, but let me kind of bring it back around. So here's an example. For battery, meaning like punching someone, I'll kind of give it down to this, which is a misdemeanor. It already includes the assault, but battery is the greater of the two offenses. So you've heard the phrase assault and battery. Okay, the assault is the attempt, if you will. So if I swing and miss, that's an assault. The battery is the actual striking. So if I actually swing and hit you, both of those pieces are there. It's an assault and battery. The assault is the lesser and included offense. So hopefully that example comes to mind. I mean, you can get that, and you understand the legal ramifications there. So Penal Code Section 1159 states that the jury or the judge, if a jury trial is waived, may find the defendant guilty of any offense, the commission of which is necessarily included in that with which he is charged, or of an attempt to commit the offense. So here's some examples of lesser and included offenses, and then we'll kind of get to the slide that's up here. So simple assault, that's an example I gave. The crime of simple assault is necessarily included in the crime of battery, mayhem, assault with a deadly weapon, spouse beating, rape, robbery, etc. Petty theft is needed or necessarily included in the crimes of grand theft or robbery. So some example of lesser offenses not included: the crime of robbery does not include the offense of receiving stolen property, nor is the offense of child molesting necessarily included in the crime of oral copulation. So I know it's really confusing, and that's again why I need you to kind of read your textbook. But the jury or the judge, if a jury trial is waived, may find the defendant guilty of any offense, the commission of which is necessarily included in that with which he is charged, or of an attempt to commit the offense. Now, a person may not be convicted of a lesser related offense that was not necessarily included in the charged crime. Okay, and that's People versus Burks. So I think that kind of clears it up for you a little bit, but I'm kind of hoping that you kind of get that. So now to kind of finish up, just a couple things left. We're going to talk about Jeopardy, not the game show, but we're going to talk about when Jeopardy attaches, and we'll talk about the Jeopardy principle and what double jeopardy means. Now, Jeopardy attaches when the jury is sworn in at jury trial, or when the first witness is sworn in at a court trial. So what does that really mean? What does it mean when Jeopardy attaches? So here's the Jeopardy principle. The basic principle in the law of former Jeopardy is that a person who has committed a criminal act shall be subject to but one prosecution for that act. When that prosecution has resulted in a final judgment of conviction, or the defendant has been acquitted, the defendant cannot be prosecuted again for the same crime. Okay, so I hope that kind of clears that up. Even if there is no formal verdict or finding that the defendant is not guilty, if Jeopardy has attached when the jury is sworn in at jury trial or when the first witness is sworn in at court trial, no subsequent prosecution of such defendant can be had for such act. Furthermore, a conviction by plea of guilty is a valid conviction which will bar a second prosecution. So another example here would be a burglar cannot usually be convicted of both receiving stolen property, okay, his burglarized goods, and burglary. Okay, so there's two cases out there. Again, you don't have to look them up, but there's People versus Jaramillo, and then there's People versus Hansard. And they clearly held that a burglar cannot also be convicted of possession of receiving the stolen goods that he took unless it's a completely separate transaction. And an example of that transaction would be if the burglar buys back the stolen goods from somebody maybe that he fenced them to a couple of days prior. So in essence, the jeopardy rule prevents a second prosecution for either the identical offense involved in the first trial or for another offense based on the act constituting the offense charged in the first trial. Does that kind of make sense to everyone? I know it's confusing, okay, but basically we're talking about when jeopardy attaches, and this is when this comes into play. When the jury is sworn in at a jury trial, or when the first witness is sworn in at court trial. And the difference between the two here, I'm sure you figured it out by now. A jury trial is by jury. A court trial is when there is no jury, that the judge is going to be that person. So again, hopefully that kind of clears that up. Now, double jeopardy and double punishment. So let's take a look at that. In U.S. versus Dixon, the Supreme Court held that double jeopardy clause does not apply to successive prosecutions if each of the crimes tried separately includes at least one element that is not included in the other. Under this ruling, attachment of jeopardy on a lesser included offense would bar a subsequent prosecution for a greater offense committed at the same time. However, jeopardy on a lesser related offense would not prevent a prosecution for a different crime. So what did I just say? There's a ton of legalese. What does that really kind of mean? One thing to keep in mind is if you look at the bottom here, double jeopardy, that double jeopardy prohibition applies to prosecutions, not arrests. These are two different things, but let me give you an example of that double jeopardy, double punishment, and maybe this will help. So, for example, double jeopardy principles would not prevent a prosecution for robbery after attachment of jeopardy for an assault with a deadly weapon committed upon the robbery victim. Meaning that they're looking at these as like two separate crimes. Okay, so assault with a deadly weapon and then I take something from you or I rob you. The crime of robbery includes at least one element, taking of property, that is not an element of ADW, or assault with a deadly weapon. Likewise, ADW includes one element, assault, that is not an element of robbery. So under Dixon, under that case, separate prosecutions would not violate double jeopardy. So in a nutshell, you can file these things separately, and that's okay. Okay, but what they're saying here is that whenever possible, all related offenses from a single criminal episode will be charged in a single accusatory pleading and be simultaneously prosecuted. And that's the Collette versus Superior Court case. Now, I know that seems like a lot, and your head's probably spinning right now. But trust me, things are going to get a little bit easier. But I really want you now to take the time to go back and read through your textbook. Take a look at that jeopardy principle again so you can kind of get a better understanding of it. Look at the double jeopardy principle. Look at those examples of lesser and included offenses. And then help yourself by going through at the end of your chapter the student review, the terminology definitions that are there, because they lay them all out for you. Take the true or false quiz and use your textbook to answer those. Look at the discussion items there and see if you can answer some of those questions. And then most importantly, look at that terminology matching quiz, because I really think that will help you as it relates to understanding some of the other things that we talked about that might seem a little bit confusing as we start to kind of move through. So with that being said, that is going to be the end of chapter 2. Again, if you have any questions, you can post them on the discussion board and I will be more than happy to answer those for you. So until next time.